Richard, how are you?
I'm very well. Hello, Peter.
Nice to see you again. Been a while.
Oman seems a long time ago.
It does, it does.
I imagine your garden is doing very well. Springtime, Richard, there.
Well, I shouldn't say it, but it's looking fantastic. All 6 acres of it.
You can see my garden behind. I've just arrived here.
Oh, hello. How are you?
That's the countryside, isn't it? Okay, well, to respect all those who connected on time, we are recording, so that's the first comment. We are having today Peter Whelan. Peter, thank you very much for joining us and for joining the IDC. For all those who don't know what the IDC is, just a very brief comment. We promote independent investigation on competition law and policy issues. We do have our own activities on a personal, basis, but also due to the pandemic. And thanks to the pandemic, in a certain way, also we are having the opportunity of having a lot of people from all around the world in some of our activities. We do have an international advisory board. Some of them usually connect with us, like Simon and Richard and Philip Marson, who's also connecting. So we have also launched some regional chapters throughout Latin America. We already had an activity on criminalization, antitrust criminalization, on the launch of a book in Chile with the Chilean chapter that is led by Nicolas Levin, also present here. So, as I said, today we're having Peter Whelan. He's a professor of law at the School of Law at University of Leeds, where he's also the director of the Center for Business Law and Practice. He has a PhD from the University of Cambridge, and he's an expert in competition law and criminal law. Peter has also provided evidence, oral evidence, to the New Zealand Parliament. He has also provided services or expert witness with the Finnish Competition and Consumer Authority. He also has led believers and workshops with Latin American authorities such as the Competition Tribunal in Chile. He's an NGA of the ICN. He's usually publishing works on law journals. He also have a monograph on cartel criminalization in Europe. So that's much more we can say about Peter, but once again, Peter, thank you very much for joining us. The subject matter, antitrust criminalization, as I said, we did touch this in the past at the IDC, and in Latin America, I think it's a very relevant issue to discuss, because recently countries such as Chile, Mexico, Brazil, maybe before, Colombia, have included criminal sanctions on their antitrust legal regimes. In Argentina, as we were talking before with Peter, in the first drafts of the bill that was enacted in 2018, we included actually criminal sanctions, mainly for bid rigging. But that was, for whatever reason that I don't know, that finally didn't reach the final text of the act. But anyway, we do have a section 300 of the criminal code in Argentina that established prison sanctions for similar cases, like sharing information among competitors that might have an artificial effect on prices, etc. So as I said, the experience in Latin America, we do have had some cases in Mexico, Brazil. I think Chile is also on the beginnings of the new law, but I think we will definitely see this growing in our region. The idea is for Peter to give a presentation of his last paper of 20, 25, maybe 30 minutes at the most, and then we will follow on with a Q&A session. So feel free to make your questions through the chat down here, or if you want to make them live, please feel free and I will give you the floor. So Peter, the room is yours. Thank you once again. Thank you very much.
Thank you, Pablo, for that wonderful introduction and for inviting me, of course, today. I'm delighted to present some of my work here. I want to really try and engage with creation of a discussion amongst us all here. So I'm not going to be too technical, and I'm going to give a bit of an overview of some of the issues that we can focus on as part of that discussion. So I'll take maybe half an hour in total to present some ideas here that appear in my latest paper. But of course, I've written a book on this topic as well, and I'll draw on some of the research from that as we go through. So I guess the aim here really is to consider how desirable it is to introduce criminal sanctions for cartels. We're focusing on antitrust law, of course, but we're focusing on a specific area of antitrust law, cartels. So desirability is the focus here, but also we need to think about legitimacy. So it may well be the case that we have a solid justification, let's say, for introducing criminal cartel sanctions. I would query that. I don't think it's as simple as that. But let's assume we do have a solid justification. It doesn't mean that we should, of course, go forward with a process of cartel criminalization, because there are issues to consider regarding legitimacy. So, for example, would it be fair to impose criminal sanctions on individuals who are part of a cartel? We might also want to consider certain human rights provisions, etc., in order to ensure that we have legitimacy. Now, legitimacy, of course, is open to interpretation. What do we mean? Does it mean that it's simply acceptable to people who are informed about the regime, or does it mean something else? For example, is it effective, or is it fair? Is it justifiable in principle? Does it adhere to requirements of the rule of law, etc., etc.? So this word legitimate can bring in quite a number of different ideas if one looks at the literature on legitimacy. Nonetheless, what I'm going to focus on here is the idea of the primary justification that is generally put forward in the literature and indeed in front of Parliament when it comes to the discussion, advocacy of criminal cartel sanctions. So I'm going to very briefly outline the concept of deterrence here and how it is used to underpin an argument in favor of cartel criminalization. Then I'm going to look at some problematic issues that we can relate to legitimacy, and then think of the specific recommendations that one might want to put forward to any agency, let's say, that wishes to advocate in favor of criminalization and needs to have in place certain mechanisms to ensure that the process is done in a legitimate manner. And I should say from the outset, I'm not here to advocate in favor of criminalization. I'm sort of ambivalent about the process of doing that. However, I will take you through the main arguments. Now, I'll start with a definition of cartel activity. We have to be careful here, because if we start to create a definition that includes some clear immoral elements, let's say, elements that clearly point to, let's say, criminality or moral wrongfulness at the very least, then we're sort of upsetting the analysis before we even start. So we're going to take a very, very narrow definition of cartel activity, and one that doesn't necessarily present immediately, at least, any immoral conduct. And so we're going to take the OECD definition, making or implementing of an anti-competitive agreement, certain practice or arrangement by competitors, horizontal competitors, to fix prices, rig bids, establish output restrictions, or share and divide markets. So we're focusing on this hardcore cartel activity. Now, we have common ground here. We know that cartels are usually very damaging to the economy if they're successful, and that there should be in place in any competition regime a prohibition against cartels in order for us to get the maximum benefit from the free market. And related to that particular point, prohibition, is that we should have adequate sanctions in order to stop cartels from forming, so for the prohibition to really take effect. That's pretty basic stuff. It's our common ground. However, we have quite a bit of scope for disagreement nonetheless. So, for example, what shape should the adequate sanctions in that context actually take? Now, we could talk about that all day. Obviously, we're going to focus here on one particular type of sanction, that is criminal sanction. And by that, I mean a sanction that can lead to imprisonment of individuals. So the word criminal can be open to interpretation. People can put forward the argument that the sanctions imposed by the European Commission, for example, although administrative in nature strictly, could be understood as criminal, at least for the purposes of human rights or fundamental freedoms. So I'm not taking that line here. What I'm saying is I'm talking clearly about criminal sanctions. I'm talking about imprisonment. So what we need to understand here is that generally we haven't seen much enforcement of competition law through the criminal sanction. So we can look at the literature and we can see that many academics point out that traditionally for many jurisdictions, cartel enforcement has been predominantly of an administrative character. So we're not talking about imprisonment as being part of a solid tradition when it comes to enforcing competition law across the globe. Now, some jurisdictions, perhaps a single jurisdiction in the United States, has a tradition of criminal sanctions in this context. So we can focus on the US if we want to look at the example of individuals going to prison for a significant period of time. Some other jurisdictions have relatively recently sent individuals to prison for usually very short periods of time, for example, the United Kingdom, but that isn't very common. Now, things have been changing for a number of years. I started studying this particular topic many years ago when I was starting my PhD at Cambridge University, and have been working on it ever since alongside other projects in competition law. And things have been changing. And we could go back in time and look at, for example, the publication of the OECD's second cartel report as a defining moment, perhaps in that particular process of change, where we have the OECD's competition committee not taking a position stating that its member states should introduce criminal cartel sanctions, but at the very least they should consider doing so, particularly if in doing that they will be respecting their legal and social norms in their particular jurisdictions. We have clear advocacy from the US Department of Justice, its Antitrust division, in terms of cartel criminalization. Globally, it's seen as something that they want to see occur, in particular because it allows for extradition to more easily take place of individuals who have harmed the US market. Now, some EU jurisdictions have indeed introduced criminal cartel sanctions. Ireland is an example, UK, Denmark, Estonia, there are others. So we could mention, for example, Germany, which has a bid rigging offence. But other countries across the globe have followed this trend. We could talk about Australia, New Zealand very recently, South Africa, Israel, Brazil, and Oman. Richard mentioned Oman there earlier. I was quite surprised when I went to Oman, before I left for Oman, to find out they actually had criminal cartel sanctions. Of course, they haven't implemented them yet, but nonetheless, we can see this trend that actually exists. Now, in terms of the Academy, we have quite a number of academics who have supported these moves in relatively detailed papers, putting forward generally the deterrence-based argument in favor of cartel criminalization, which I will take you through so that we understand the basis for that particular position. So we're starting here with a theory of deterrence. So we are looking forward. We want to prevent future activity from occurring. We're not looking back to some past cartel, let's say, and punishing it because what happened was immoral or morally wrongful or severely harmful, let's say. We're looking forward. We're hoping to stop the formation of cartels in the future by imposing sanctions. That's what we're talking about with deterrence, of course. The central idea here, if we're going to follow the law and economics approach, is that we consider the expected cost of the activity, so price fixing, let's say, hardcore cartel activity, and the expected benefit. So we need to ensure to deter that the expected cost actually outweighs the expected benefit. So the punishment imposed is greater than, let's say, the cartel profit divided by the probability of punishment. So we can see that this is a strong theory when it comes to the literature and, of course, to the officials in support of cartel criminalization. So we can find statements such as criminal sanctions are the most meaningful deterrent to antitrust violations, or they send a message to other business executives about the risks and penalties for this kind of behavior, a message that would not be sent with other types of sanctions. So what are the actual steps here? Well, I think just to pare it down, we can take 3 steps. So the first here, I should say before I take a step, we're going to assume no criminal sanctions exist. We're going to assume that we have fines being imposed on companies that have engaged in antitrust activity. So we're going to focus on cartels, and we're going to assume that the sanction is an administrative one. What we're going to do is we're going to see what size that particular fine should be. Then we're going to explain why we cannot actually impose that fine. So there's a deterrence gap. And then we talk about criminal sanctions, so imprisonment, filling that deterrence gap. This is the general argument. Now, you will see in the literature, of course, additional arguments to this particular one, where they might talk about, for example, sending a message to individuals. They might talk about moral wrongfulness. They might talk about the advantages of cartel criminalization in terms of giving criminal powers of investigation to the authorities and other things like that. But this essentially is the basic argument when it comes to deterrence. So let's start with the first step here, where we're determining the size of the effective fine to deter. So we can go back to Wouter Wills's papers, and these are relatively old at this point, but nonetheless so robust that in fact I would happily cite them, and I think they are very useful in this particular debate. So Wouter in 2002 and later in 2005 estimated the deterrent fine to be around 150% of annual turnover in the cartelized market. And you can see on the slide there the sort of inputs that he put in there, but you can see from 2002, 2005, some of the inputs change, but the overall figure doesn't change. So we have an increase in the gain effectively and a reduction in the probability of detection due to leniency programs. We see others, though, who come to similar figures regarding this deterrent fine. Greg Verdon in the United States has risen the fine, has caused the fine to rise in his estimation as a result of taking on board the fact that interest should be considered, because this unlawful gain will be accumulating interest over time during the course of the cartel, or at least up until the time when punishment is or indeed when the gain is spent. Nonetheless, we need to consider the interest that would be paid on that. Wills's figure does not contain that. So in addition here, we could mention that the figures here are probably conservative estimates. Now, I'm not going to go through all of these particular studies, but there are a number of studies I'll just put here for illustrative purposes on this slide. And the next one, and we can see here that there are many different studies that actually bring forward higher figures that can go into that particular equation to figure out that, in fact, the effective deterrent fine using this particular type of theory would in fact be higher. So we can see studies with Connor and Landay, Bolotova and Connor, but there are others from Komamania, for example, and Smuda here as well, relatively recently. Of course, there are some assumptions being made in the creation of these figures.
Can I interrupt?
Yes.
I remember Sean Connor that you mentioned here. When he was writing on treble damages, actually, he one of his papers, he says that that definitely doesn't exist in the States in practice because of all the cases he has studied. There's never treble damages, but almost one, not three. But before we go,
yes, that was to do with the prejudgment interest, I believe.
Yeah,
the lack of prejudgment interest.
Before we continue, sorry, I would like to launch a poll that we mentioned now that we have quite an interesting audience listening to your presentation, and then we might repeat it at the end of your presentation if you agree. This is, I don't know if you see it. The question is very straightforward and very clear. Are you against or for criminal sanctions for antitrust conduct? That would give us an idea of the audience. We already have 40% that voted. We had this question, as I was mentioning to Peter, before the Chilean reform. Some of our colleagues present today were against, and now they are for. Would be very interesting to listen or to know more about why they changed their opinions while they were discussing the act in Chile. So we have a 70% that are for and 23% of the audience that are against.
Very good. Well, so I'm quite surprised by that. That's quite a high number. I suppose how many are we? 20?
22 now.
Okay, fine. Okay, so I'm amongst friends. Is that the idea? Well, I was hoping that no one would be in favor, and at the end, everybody would be in favor, having listened to my presentation. But we'll see how we get on. Just to take us back, then, I was looking at the idea here of determining the size of the effective deterrent fine, and there are a number of studies that one could rely upon to demonstrate, perhaps, as best one can, given the limitations of these studies, that the figure that Wills comes to is a conservative estimate. So perhaps a bottom line, and that's fine, even if it is conservative, it can still be used here in this particular context. Okay, so the point is that if we rely upon these studies, we would actually increase the fine, and the fine of 150% is enough, is sufficient to demonstrate the argument. So the next step then is to think about why we cannot actually impose that particular fine. Well, the point here is that we've increased the fine to take account of the rate of detection and successful prosecution not being perfect, so we don't actually have this money being made. Also, we have the profits being spent potentially in taxes and dividends and salaries, etc. So the idea is that the company may be forced into liquidation if the effective fine is imposed, and this would be unacceptable for various reasons to do with costs and negative externalities. Indeed, we may have further concentration of the market as a result, and let's not forget, a market in which we have a cartel already, so it's probably concentrated as it is, given markets. So we might have a problem with imposing this particular fine. So that's why we move to some other sanction, and we go to the individuals. And sorry, I'm just looking at the comments here. So we go to the individuals, and we try to ensure that the individuals' interests are not lined up with cartel activity. Now, the point here really is that it's difficult to ensure you have deterrence when, in fact, the sanction facing the individual is merely financial. And the argument is that the firm itself can indemnify the individual. So if we have a firm having an interest in ensuring that cartel activity occurs because it's profitable to it, then that firm has an interest in indemnifying the individual who is suffering a financial fine if the cartel is discovered. So this effectively would neutralize, one could argue, the advantages of individual punishment. So this is where custodial sentences come in. The idea is they cannot be indemnified by the firm. The cartels will not accept money to run the risk of going to prison. And there are very strong statements in the literature to that effect. For example, Lyman states, to the businessman, prison is the inferno, and conventional risk-reward analysis breaks down when the risk is jail. So the argument is one of deterrence. Now, let's think about some of the problematic issues here, because that deterrence-based argument clearly has some limitations, but even if one were to accept it, it doesn't mean that we should go forward with a process of cartel criminalization, because in doing so, we might be actually lacking some legitimacy here, or at the very least, we wouldn't be doing what might be necessary in order to ensure that we have the most legitimacy in the process. And with that, some potential advantages in terms of support from stakeholders and the generation of resources that such support can lead to. So I think we need to consider here various challenges that need to be overcome in order to ensure that legitimacy, theoretical ones, legal ones, practical ones, etc. Now, obviously, I can't consider them all here, and I'm already coming up to 20 minutes at this point, but I'm going to focus on a couple of them. These aren't necessarily the most important. There are other challenges, but I think there are certainly some of the more difficult ones, certainly A and C would be. So what are they? We're talking here about efficiency. So cartel criminalization, is it efficient? Or can we make it efficient? Also, we can think about the leniency program that exists in the administrative context and how that can be harmed potentially by cartel criminalization. And also we can consider public attitudes on acceptability of imprisonment, and those attitudes perhaps can feed into how one can create an offence that is more acceptable to society and less susceptible, let's say, to jury nullification. So we can try to have some form of legitimacy present by linking the offence itself to some form of immoral behavior, perhaps. So in terms of efficiency, we have to be careful here. Just because, well, let's assume that it's true. Let's assume it's true that cartel criminalization is effective. Let's assume that it actually stops cartels from forming. It doesn't mean, even if we were to establish that we have established an economic deterrent-based approach to criminalization here, because we have to think about the costs that are involved. So it may well be effective to send individuals to prison for cartel activity. It stops all cartels, but it might be so costly to do so that it's not really worth the effort. So we're talking here about an economic crime after all. We're not talking about necessarily something that is morally egregious. We're not talking about, you know, a murder, let's say. We're talking about something that has its effect mainly in terms of finance, in terms of welfare in society, let's say. So we need to consider costs. And there are, of course, many costs with criminalization. So we set up the apparatus, more robust human rights guarantees need to be met. We can consider that a cost, trials, imprisonment itself, of course. And also, and importantly, we're taking otherwise productive members out of society, individuals who create wealth in society, or certainly benefits for individuals in society and society more generally. They are usually the productive members of our society that are engaging in these sorts of things. So we can consider that a potential cost too. Now, of course, the economists here would talk about looking at marginal cost equaling marginal benefit at some point when you impose a given criminal sanction. I don't think we can do that. We can't do that because simply we can't determine at any given point how many cartels we have. So we can't compare the before and after in terms of criminalization and figure out what we've actually benefited from it. We might be able to figure out the cost before engaging in a process of cartel criminalization, but I don't think we're going to be able to figure out in any scientific way the actual benefits here, because cartels are inherently secret, as we know. So therefore, we can't compare the before and after. We can just make some sort of estimate, perhaps, as to how effective the criminal sanctions might be and how many cartels we might end up prohibiting or stopping from occurring, let's say, and therefore we can get some measure of the benefits from that. But it's all subject to, of course, empirical evidence, which we don't really have. So we can depend on some anecdotal evidence about the idea here of no cartels, for example, offering to go to prison in lieu of a fine. So the idea of prison being quite effective. And if it is effective, then of course it will reduce the incidence of cartels and save some money. So we might say perhaps there are sufficient economic benefits from cartel criminalization, and that would outweigh any of the costs. But this is all very speculative. We could, of course, engage in some activities that might reduce the costs that these regimes will be facing. For example, we don't need to have necessarily long terms of imprisonment for these sorts of lawbreakers. We could focus on very serious cartels in order to ensure that message is indeed conveyed. We can use some mechanisms in this context to reduce costs. Now, some of these mechanisms, for example, immunity programs, may well be available already in an administrative setting, but they might be able to bring us some additional benefits in a criminal setting that would help to ensure that we're generating some additional benefits here and setting off some of the costs. We could, for example, ask convicted cartelists to contribute towards the cost of their prosecution. We have a legislative provision in Ireland to that effect. And of course, we can still impose fines on individuals as part of this process. Okay, so that's so much for efficiency. I could go on. There are many different things that were raised there, and we could discuss those perhaps in a few moments when I finish this presentation. But an easier issue, perhaps, before I move on to the final one, and that is dealing with administrative leniency. So we have common ground here that cartels are usually secret. Certainly the hardcore cartel activity, cartels that are aimed to disrupt the competitive process and make profit for participants are by and large secret. And in order to penetrate that secrecy, we need to have a functioning leniency program for companies to come forward to reveal the cartel, give information about it, and ensure we have prosecutions. Okay, so we don't want to destroy that process. Leniency is important, but if we're going to introduce criminal sanctions, then we might actually have some tension here. So the firm, for example, that's thinking of applying for leniency may care about its employees. Let's assume we're talking about a board in a firm, in a company, that doesn't comprise the individuals. It may well, but let's say it doesn't comprise the individuals who have engaged in the cartel activity. That board, nonetheless, may care about some of these individuals and losing them in terms of going to prison could affect their business, but also it could affect these employees' families, and they may care about that. Or they could just care about the idea here of ensuring that employees that have engaged in cartel activity actually cooperate with it so that it manages to get immunity from a fine or a significant reduction of its fine. So the idea here is that we have tensions that come into play when we have criminal sanctions. Now, the obvious solution here is to create a criminal immunity program. So you give automatic immunity from criminal prosecution to those employees in the firm that has been the first to report the cartel. We might give further discretion for additional reductions, perhaps, or immunity. And what this does, of course, is to help protect the reporting individual. So we have this criminal immunity program, we have the individual who reports under it, and it protects that individual. And it can, in fact, according to the theory here, create additional races to the regulators. So that individual may, for example, go to the regulator and report the cartel without the company being involved. Maybe the person was fired by the company, has a grievance against the company. So it creates this potential race that the company itself must be aware of and may, in fact, cause it to report. But importantly, we need to have a link here with the administrative immunity and the criminal one. So we go from the specific, from the individual, to the group here. And the idea is that we allow for the automatic criminal immunity for the cooperating employees of the firm that has been granted administrative immunity. So this is the idea. Now, it's fairly straightforward, but we can see some resistance to this in countries that may have a tradition of mandatory prosecution. So we have countries in Europe that have no criminal immunity programs, in theory at least. And there may be opposition as a result of that sort of tradition, whether it's constitutional or merely legal. And we can see that that's been recognized in, for example, the latest directive on the ECM Plus directive, Article 23, talks about this idea here of allowing for criminal immunity when sanctions exist. So we need to ensure that we have both this individual focused idea, create this race for the individual, but also we have the group focused idea where you have the company going forward and taking the employees with it. So you have two possibilities here. So they stand apart effectively. The final point that we can talk about, and I suppose this is really relevant to legitimacy, is the idea, as most people would understand it at least, perceived legitimacy, public attitudes to cartels. So I think a clear question here that comes out, I'll spend 5 minutes on this and then I will leave it open for questions. Okay, so what we need to think about here is moral wrongfulness and what that means. But we need to understand here that it's an important question, the idea of whether cartels are morally wrongful, inherently wrongful, because even if we have a solid deterrence-based reason for cartel criminalization, we can get good benefits from having a link between the criminalized behavior, criminalized cartel activity, whatever that might look like, and morally wrongful behavior. So you can get some benefits from it, but also you can avoid some problems. For example, the claim of over-criminalization and potential jury nullification or hesitancy of judges perhaps to impose sanctions when they don't see anything wrong with the activity. Also, we can go back indeed to the economic deterrence argument and talk about efficiency, and we can talk here about self-enforcement. And if we have the criminalized behavior lining up with morally wrongful behavior, there may be an internalization of that particular norm, and that reduces the cost of enforcement because we have self-enforcement as opposed to policing. And also, of course, we need to ensure that significant investment is placed into the criminalized regime. There are many issues to overcome. It requires significant investment before you see any benefit from it. And so if you have this idea of a public attitude, understanding cartel activity to be morally wrongful, we might be able to benefit in that particular regard. So we can see clearly in the literature that we have individuals outlining the importance here of moral wrongfulness when it comes to cartel criminalization. So we can see individuals talk about unification as a potential outcome, or disproportionality as a potential outcome if we have the criminalization of cartel activity with no real link with moral wrongfulness. Now, often there is a contrast made with the US, at least in terms of public attitudes to cartels. I think that's questionable, but we can see here that in a recent survey, this is conducted in 2014, published in 2017, undertaken by Andrea Stefan at the Center for Competition Policy. He surveyed 3,000 representative individuals across 4 jurisdictions, including the United States, the others being the United Kingdom, Germany, and Italy. And we can see, just to take for example, that we have imprisonment being an acceptable response in terms of punishment for 27%. Now that's up quite a lot from 11% of an earlier survey from 2007. But if we compare it to the United States, it's not that much higher. We're not talking about 90%, we're talking 36%. So one can query whether really there is, if this particular survey is anything to go by, whether there really is such a strong public perception of the immorality of cartel activity. Now, I'm going to propose one particular solution here, and then I think I will stop without going through the recommendations, so I don't have to rush. I think a very useful way of ensuring that we have this lineup between criminalized behavior, cartel offense, let's say, and morally wrongful behavior is to look at the UK regime, the recently reformed UK offense. Now, there's one aspect of that particular regime which is going to cause it to fall apart, I think, in reality and practice, and that's the defence that was introduced on the 1st of April 2014 to do with taking reasonable steps to get legal advice. But I'm putting that aside. I'm not here to say the UK regime is a great one, we should follow it, but I think one of the elements in the reformed offence could certainly be used here to highlight how one can approach this issue in a reasonable and workable way. And here what we talk about is the idea of providing circumstances in which the offence, the criminal cartel offence, will not be committed. So we could have public publication of the agreement prior to any implementation, or the notification of the agreement to either to customers directly. Perhaps we could talk here about the entities that might request a bid to be submitted, or the competition authority. So effectively, I'm paring this down, I'm being a little bit simplistic here, but nonetheless, the point can still be made. We can have a publication or notification of the agreement in order to ensure that we have a line-up with some form of immoral behavior, notably deceptive behavior or deception. So what is deception? Deception occurs where a person communicates a message with the intent to cause a person to believe something that's not true, and that person is thereby led to believe the truth. Now, if we have a lie that's believed, we clearly have a deception, but we might have deception in other instances where, for example, somebody states something that's completely true, but it's stated in circumstances where the person receiving the communication is intentionally led to believe something that's not true. So we have to understand that deception can occur even when we don't have lies. Nonetheless, let's assume that we have a cartelist who lies. So the cartelist, whether it's the company on its website, or whether we have a statement from one of its agents saying this is the best price, it's a competitive price, whatever it might there's an express statement regarding cartel, regarding the absence of cartelization when it has in fact occurred. It may also be present deception when there's no mention of the cartel, because the cartels may well be aware of the fact that the receiver of the message, this is our price, it's the message, makes the assumption that it's competitive. And by not disabusing that entity or individual of that particular belief, then we have deception. We have this intent to mislead. But obviously where I'm getting at here is where there's no deception, where the cartelist reveals the existence of the cartel prior to sale, either by notification or publication. At that particular point, we have no deception. And I'm not saying that necessarily there will be no impact on the market and that we shouldn't have, let's say, administrative sanctions eventually being imposed on the company. But we're not talking about that. We're talking about whether the criminalized behavior lines up with deception. So by having this particular approach to publication and notification, we can try to do that in a way that's workable. It doesn't require resources of the authority to go through notifications to determine if it's an okay agreement or not. The mere notification of it is enough to make this work. So I think I was going to go through sort of summarizing some of the specific things I've mentioned, but I don't think it's really necessary at this point. So I'm going to stop it there so we can have a bit of a discussion about my running through it. So I'm going to stop sharing.
Thank you very much, Peter. Thanks for the very clear presentation. We do have some questions, but before I give the room to some of the questions I've received, I remember, as I said, there was a discussion in Chile, and we have very important people here who might maybe correct me if I'm wrong, Jorge Grunberg, Ricardo Riesco, the national prosecutor in Chile, Nicola Levin, Javier Tapia. But I remember, as I said before, the discussion in Chile, how that evolved during their discussion in the Congress. Most, as far as I remember, most of the lawyers of the bar were against criminal sanctions when they were investigating the Tissue paper case. At the end of the case, the opinion was sort of changed, and I remember it was something like 70–80% of the public opinion against, or sorry, for criminalization of antitrust illicits. So there might be somebody from Chile who might also illustrate this. But as I said also when we were speaking before with you, Peter, in Argentina, when we were discussing, one of the main reasons, or one of the main reasons why they didn't accept criminalization in Argentina was, in my opinion, the wrong reason, in the sense of, hey, yes, in Europe they don't have criminal sanctions, and I think that's wrong, because in Europe as a continent, definitely and obviously you don't have criminal sanctions. But if you go to each of the countries, let's say the UK and those countries that you already mentioned, they do have criminal sanctions. And if I was looking at a book that I showed you. This is The Art of the Steals, one book on one of the main cases on criminal sanctions on the cartels of, between Sotheby's and Christie's, that you may recall. There was a very good book on that. But so, I mean, to make a long story short, at least my interest or my theory here is mainly based on deterrence, as you mentioned, and also with all the problems that obviously they exist. But not exactly to get people into prison. I mean, I think the deterrence purpose is definitely something we need to have in our laws in order to make our, at least antitrust law, more deterrent. Obviously, there are problems that you mentioned, in our case, the leniency program, and some other problems that we might have. But I mean, what would you say to those who think or say that first, in Europe you don't have? Do you agree with what I say, or not? And do you agree that there's an over deterrence in the case if you have criminal sanctions in these types of cases?
Okay, so first point then about the EU, it's pretty clear we don't have criminal sanctions at EU level. So the Commission doesn't technically impose criminal sanctions as we would know them, certainly not sanctions that I'm using for this presentation. So it's imprisonment I'm talking about, and they cannot send people to prison. That's clear. We can look at Article 23 of Regulation 1 of 2003, the implementing regulation, and it states therein that the decisions of the Commission are not of a criminal nature. So fines imposed are not of a criminal nature. So that's clear. I think there are arguments that you could, with the agreement of all the member states, introduce criminal cartel sanctions at EU level. I think there are even more sophisticated arguments that you could do so without the agreement of all member states. But I don't think that that's going to happen. And I think there's a political question there, really, and that is a very big one when it comes to whether this should occur in any given jurisdiction, never mind coming from EU level. In Europe itself, there are many countries that, on the books at least, have criminal cartel sanctions. I've mentioned a couple, but you could add to that. You could add France, you could add, where was I going to think? Malta, no. Slovenia, you could add Italy, you could add Austria for bid rigging. You know, it depends on how you look at this idea of the cartel offense, because sometimes you will have a very broad criminal offense, let's say, that could capture cartel activity. It's not called criminal cartel offense. It doesn't use the word cartel. It may not even use the word anti-competitive, but you know, some sort of conspiracy to defraud, perhaps, or some sort of fraud offense involving companies could maybe bring in cartels. And sometimes you see that in claims in the jurisprudence. But I would say there are a good number of countries in Europe, indeed across the world, that on the books, in theory at least, have criminal sanctions. There are very few, however, that have made it's successful in the sense that you regularly see individuals going to prison. In the UK, 5 individuals were convicted of the criminal cartel offence from entry into force on 20th of June 2003 up until the current day. 5 individuals, all from guilty pleas. 3 individuals went to prison for relatively short periods of time. And there's a whole reason for that. I won't get into and bore you with it, but you know, it's not as simple as just simply saying that they got caught and there was sufficient evidence against them. They really just didn't want to go and serve time in the US. That's why they pleaded guilty. They had to prove dishonesty at the time, and someone's raised it in the question there about dishonesty. So, you know, they had to plead guilty and accept the idea that they had been dishonest. But nonetheless, they did manage to receive relatively short periods of imprisonment. What does occur?
Great.
Just the second point you mentioned, sorry to stop you, the over-deterrence point. I think it's difficult to know. And if you look at the economic deterrence theory, you can construct an argument that without criminal sanctions, it is suboptimal, full stop. But there are certain limitations in that argument. There are certain assumptions one has to make. For example, whether cartels are rational. We can also question how often they get caught. We don't know because we don't know how many cartels are out there. So whatever number we discover, we're not sure what percentage that is of the whole. We don't know what the rate of detection really is. We can use detected cartels to work that out mathematically, but it is on the basis of a number of assumptions that don't really work in the world. And so do they over-deter? Well, I don't know because I don't have access, like anybody else, to the empirical evidence. But I think if we're to make certain assumptions and use what available information we do have, there is a credible argument that there is under-deterrence because of a lack of criminal sanctions.
I agree. And in jurisdictions like Argentina, at least, I would definitely say that there is a lot of under-deterrence for various reasons that has nothing to do with our presentation. But I mean, that might also help us here. There's a related question with that made by Nicolás Durrie, a criminal lawyer here in Argentina. He asks, what about double jeopardy, non bis in idem, a double sanction for same grounds, criminal and administrative? Anything to comment on that?
Yeah, that's a good point. Thank you for that question. I wrote a paper on this and published it in the Northern Ireland Legal Quarterly, so I can send that on to you, Nicholas, if you want. But yes, you've got to be careful here. Obviously, you've got to ensure that there is a protection of double jeopardy. And if you actually look at Europe in particular, you can see that even a administrative regime raises the possibility of Article 50 of the EU Charter, which contains the prohibition on double jeopardy being applied. So they talk about criminal sanctions, but they would in fact apply to EU level competition sanctions. Now, in terms of whether it would be problematic, well, I think if you've got a criminal sanction against an individual, and you've got, let's say, either a criminal sanction or administrative sanction against a company, then you don't have a lineup of person. So you need to have unity of the person involved, the legal person or the natural person. So there's no lineup with that. So the company is distinct to the individual. So even if you have a successful prosecution of the company, it wouldn't prevent, according to Nibis and Idem, wouldn't prevent the prosecution of the individual. Now, there might be one exception to this, and that is where we have an undertaking in EU law that is in fact an individual. So at EU level, the fines are imposed on undertakings, and they have to find within that undertaking the economic entity that's active on the market. They need to find within that undertaking a person to impose a fine on, okay, because they can't actually enforce the decision unless they actually render it against a person. So they find the person, and they usually find a legal person that is responsible for the undertaking. It doesn't necessarily have to be the parent company, it can be sometimes, but it could just be the company for whom the employee works directly, who is engaged in a cartel activity for the company. Okay, so that said, there is a possibility at least in EU law of imposing a fine on an undertaking that is a natural person. And there are examples of opera singers, for example, that were found to have been undertakings for the purposes of EU competition law, and therefore could be fined on that basis. So if you have an undertaking being fined at EU level, that's a person, and you have that person then being subjected to criminal sanctions in a member state, I think you could raise a good argument that Nibis and Idem would apply, and you'd have to stop one or the other. Whichever one came second, you would have to stop.
Thank you. There's a question by Simon Holmes. Simon, if you want to start your video, or not, there you are.
Sure. No, my question was that, as is fairly well known, one of the main reasons why the UK system was ineffective was the requirement to prove dishonesty. And I just wondered, from your overview of different countries which have criminalized cartels, how many of them have something equivalent to a requirement to show dishonesty? Clearly, the requirement to show dishonesty was seemed intuitively correct at the time, because it aligns with people's instinctive idea of something being criminalized, and it goes to the legitimacy point which you were talking about. But in practice, it proved to be an almost insuperable hurdle. How have other countries had to how have they dealt with this this balancing?
Okay, that's a very, very good question. It is true that dishonesty was part of the UK cartel offence. So any cartel, let's say, that's discovered now that occurred between the 20th of January 2003 and the 1st of April 2014 will be subjected to that regime. So you would have to prove as a prosecutor dishonest cartel activity, let's say. So it still exists in the UK for that period of time. There were other countries. It's a common law concept, really, this idea of dishonesty, as we would know it. And there's a distinct test, is probably too strong a word, and I'll get to that in a second, but there's certainly case law in the UK that's relied upon in order to substantiate whether something is dishonest or not, and substantiate a claim that something is dishonest. There were other countries that looked at the idea. Australia did introduce criminal cartel sanctions after the UK. In 2009, they had a draft that included dishonesty, but they eventually got rid of that. So they introduced the law without requiring dishonesty thereafter. If we look at the US, they don't require dishonesty. They use a different phrase, of course. They use the word conspiracy. And, that opens up, obviously, lines of inquiry when it comes to interpretation in court. There's a whole lot of improvements on that. So there aren't many countries that have used the word dishonest or dishonestly in the creation of their offence, specifically for cartels. If we look at some of and those who considered it eventually on the evidence available, the UK experience perhaps decided not to do so. not to keep it as part of the offence. If we look at those other countries that might have some moral content that's obvious from reading, let's say, the wording of the offence, those offences, by and large, not being created for cartel specifically. So, your conspiracy to defraud or those sorts of fraud-focused offences that might suggest some form of dishonest deception or dishonest activity. They weren't created for cartel activity. The question is whether cartel activity would fit within them. And I'm not aware of particular cases where that has been found. And so I don't think it's a major part of the regimes, let's say, that are criminalized, this idea of being dishonest. I don't think it should be either. I think you're going to run into problems when it comes to immunity, let's say. If you're an individual and you are a respected individual of your community, okay, you get caught engaging in cartel activity. You are facing the risk of going to prison. You don't want to do it. So you're going to admit that you've broken the law and you're going to put up with the humiliation involved. But are you prepared as an individual to go into court as Queen's evidence and say, I'm a dishonest person. I actually did break the law and I was dishonest. And that individual over there was also dishonest. I mean, that's a difficult thing to expect of an individual. And I think you'll end up with a hostile witness at that point, or at least a very tricky witness. So there are, in addition to that, just to get back to the point about test, the UK, I should say the law of England and Wales really, but there has jurisprudence on this idea of dishonesty, because the Theft Act includes the element of dishonesty as part of it, a part of the offence of theft, and other offences. And there is a test. That's changed recently, but at the time you had this two-part test where you had a subjective element and an objective element. So the idea, first of all, we'll take the objective one, that honest people, reasonable and honest people would find the activity to be dishonest. So you've got the word dishonest in the test, let's say, doesn't get us very far. And also the subjective element that the cartelist would know his activity was dishonest according to those standards. That's just very, very difficult to prove. And I think going back to Simon's point that, that comes out of the experience really of the UK. Its enforcement record is pretty poor. There are no convictions at trial. Everything has been through guilty plea, and there are certain reasons for that. I think one individual, two individuals in particular, were badly advised, perhaps, in terms of pleading guilty, and they should have taken their chances in front of a jury, questioning whether it's dishonest. But I think the idea of dishonesty is a bad thing to include as part of the definition. That's what I'm getting at. Very, very few countries do so.
Thank you. So we're not out of line now.
Thank you, Simon. Thank you, Peter. There's a question by Jorge Grunberg from Chile. Maybe while doing his question, he might illustrate on the evolution of the Chilean case, but I think his question has related with another country, not Chile. You're muted, Jorge.
It's Greece, I think, is mentioned in the commentary.
Yes. Thank you, Paulo. Thank you, Paulo. Hi, Peter. Many thanks for your interesting presentation. I got a little bit curious about this mention to a Greek case you made on one of your slides regarding the automatic link between administrative leniency and criminal leniency. I noticed that apparently you are telling us that this would suggest that as doing an exception on the automatic link. I would be interested in hearing about this case because
Okay, well, thank you for raising that. I did rush over that a little bit. The point I was making was that you have the example there of Greece that had the linking of a criminal immunity policy to an administrative immunity success. So if you were a company that got immunity from your fine, then the individuals within that company would not go forward for criminal prosecution. My point was that they didn't go further than that to establish a criminal immunity policy that stood alone. So the individual couldn't get criminal immunity unless that individual was part of a company that were to go forward and seek immunity. So an individual might be sitting on evidence, maybe not even employed by the company anymore, and doesn't like how he was treated at the company, and is worried about criminal exposure, or even just simply knows there's a criminal, there's a criminal immunity policy in place and wants to get one back at the company. Let's say you could have that position. That would be good for enforcement because it creates an additional race. And the company might be aware of that and would have to consider it in terms of whether it should go in sooner rather than later for administrative leniency. But the point I'm making is that by not having that standalone possibility for the individual to apply for criminal immunity, you don't create that extra race. And you don't give that individual the possibility to go back to the company. And that needs to be avoided, is my view on the point.
Okay, thanks.
Thank you, Jorge. Thank you, Peter. Peter, I still have a couple of questions, but to respect the timing, as we said at the beginning, the idea is to have not more than an hour. We already are 1 hour and 3 minutes long. I think it's a very timely issue or moment to discuss these sort of issues. Latin America is making a shift on this regard, definitely. As we said at the beginning, Chile, Brazil, Mexico, Colombia, many countries already have some criminal sanctions for antitrust, anti-competitive conducts. We are having Ian Forrester getting in now while we're finishing. But anyway, welcome, Ian. We're finishing. But anyway, you're always welcome. The idea is to continue our discussions on criminalization of antitrust as we did in the past with Chile. There's some things going on also in Brazil, Mexico, and Colombia. We hope to have something, some new developments in Argentina soon. So we'll keep you posted on that. But once again, thank you very much for joining us. If you want to make any last comments, unless Ian wants to comment something before we finish.
Never trust a judge to be able to tell the time. Sorry.
That's okay. Next time.
I think criminalization is a much better way to go, even though it's bad for the budget in Europe. I think that Europe is drunk on fines, and there is an excessive enthusiasm. It's maybe less now, but a few years back, fines were the measure of the effectiveness of the commissioner, and that's a bad measure of effectiveness. And I think that fines should be reserved for gross infringements, not for new infringements. And we should realize that the burden on a company, not the sum of money taken out of its pocket, but the change in behavior which is imposed by the decision. I'm really sorry that I'm an hour out in
well, that's okay. But I guess I could just simply respond by saying, I agree with what you've said. In fact, I'm just about to finish a book for Oxford University Press on parent company liability, which is used obviously at EU level and in EU member states, some of them, and no doubt a good lot more will be doing it in future. So I've written a book about that and trying to look at it in terms of legitimacy as well, which hopefully will be out by the end of the year or beginning of next. But I'll get in touch to let you know about it.
I think the problem with parent subsidiary liability, it's a kind of game of poker or chess. The reality is that the parent company doesn't, well, many times, is that the parent company doesn't know anything of what the subsidiary's employee has been doing. But in order to get the parent company into the process, the purpose of getting the parent company in is that the fine can be far much higher. And so instead of being 9 million, it's 200 million. But what we should be focusing on is whether the conduct in question, and it always comes up in cartel cases, rather than other cases, whether the conduct in question involved individuals who can be identified and who are guilty of what we should regard as an economic crime. And if we can't do that, it's simply pretending that the parent company is guilty, yeah, sort of, and that the parent company must pay a very heavy fine. Well, I'm not sure that in terms of enforcement, that's the best pattern. We should be learning from the United States, where the criminal penalties demonstrate, or the low level of domestic infringement demonstrates the effectiveness of the personal penalty.
What's interesting is, just to finish there, perhaps, but what's interesting is that the courts are very much in support of the Commission's policy and approach in this regard, with respect to parental liability, I mean.
Yes. Yes, and I cannot say you're wrong.
Can't say anymore.
Okay, thank you, Ian. And Ian is also part of the advisory board of the IDC, Peter. So let me ask Ian to commit himself for another activity on maybe these issues, because I remember reading an article, Ian's article, on fines in Europe, and that they might be against the human rights, section 6 laws, and how the Commission works as a prosecutor and also deciding cases, etc., etc. That might also apply to some issues related with some of our authorities here in Latin America. But anyway, to respect the timing, as we said, we don't want to make it more than an hour and 5 minutes. Okay. Thank you very much.
Well, thank you. Thank you for having me. It's been a pleasure.
Okay, thank you very much, Peter, and thanks everybody for joining us. We will post this on the YouTube channel of IDC so that Ian and everybody can watch it later on time. Thank you very much and enjoy.
All good. Thank you very much. Take care.
Thank you.